Welcome to the top 12 highlights from Civil Liberties as we look at Chapter 14 in the online text, Chapter 15 in the hard copy text. I'm Mr. Robin. Thank you for joining me. Let's take a look at the top 12 highlights from this chapter on civil liberties. Well, first of all, let's start by parsing between civil rights and civil liberties. Okay, the difference here is we look at civil liberties as protections against individual actions. Think of the idea of freedom of speech, of the idea of free exercise of religion. All of these are civil liberties in terms of being addressed. The right to have the freedom to have a lawyer with you present in a courtroom if you're being accused of a crime. All of these are civil liberties actions that are being taken. Civil rights is a protected class, and looking at the equal protections and the due process of the law in terms of a protected class based on race or gender or disability or sexual orientation, as we have seen played out in the courts over the last, 50, 60 years. So that's really the difference. Civil liberties, much more individual protections for individual actions. Civil rights, protected groups of people, a protected class of people in terms of equal protection rights that they have under the law. So that's really important and specific to parse the two, because it is very nuanced in those terms. In this chapter, we're going to look at those individual protections. In the next chapter, we'll cover the civil rights aspects and those classes of classifications of people, the groups that we're talking about in terms of protections under the law. Now, we can't talk about civil liberties without talking about selective incorporation, a concept that is always hard for students, but we're going to simplify this. It is right there at the bottom of this screen. It is applying the Bill of Rights to the states on a case-by-case, amendment-by-amendment basis. Now, as an AP reader, I will tell you, in looking at this, when they ask you to define selective incorporation, they have a high bar on a definition. They expect you to know those. So you've got to include here that they're applying the Bill of Rights to the states. That's the important piece, because the Bill of Rights didn't apply to the states before the incorporation of the 14th Amendment, which ultimately led to the selective incorporation of all of the amendments in the Bill of Rights that have had an impact there. Not all of them, but most of them up to this point. Now, it's case by case in that it didn't incorporate the Bill of Rights entirely all at once, boom, done. It was case by case, amendment by amendment. And in some cases, like with the First Amendment, you've got the 5 freedoms in there. You know, you got freedom of the establishment of religion, freedom of the free exercise, freedom of press, freedom of petition, freedom of assembly. And each one of those had to be selectively incorporated. So again, amendment by amendment, but it even parsed it out case by case for each of the 5 freedoms that we see here. So applying this to the states is important here because you're doing it amendment by amendment, but you're doing it through court cases, through precedent, based on what we talked about in the last chapter, through the judiciary. You're protecting rights and liberties based on what you see here because of the due process clause in the 14th Amendment. It's basically taking these rights that the citizens have against the national government, and with the 14th Amendment basically saying, you know what, due process applies to all of the individuals, including and their protections from government, including the states. So think about the Civil War and the end of the Civil War and Reconstruction and the adoption of the Reconstruction Amendments. The 13th Amendment abolished slavery. The 14th Amendment, we see the Citizenship Clause, we see the Equal Protection Clause, and we see the Due Process Clause. And we'll come back to those in a second. But then we see the 15th Amendment basically giving suffrage to black men, because women, sorry, they still don't have the right to vote. But going back to the 14th Amendment here, these 3 Reconstruction Amendments were designed to address some of the issues they knew were going to come up in terms of what was going to impact individuals as we try and bring the country back together and try and make sure that the rights of the people are enshrined in the Constitution. The Citizenship Clause, for instance, making sure that everybody knows that if you were born in the United States, and this applied to former slaves that are now citizens, they are citizens of the United States government. No questions asked. and that was an important point because there would be no middle ground in terms of a state being able to say, oh, they're not a citizen, or we're going to grant citizens the way we see fit. No, the national government said these people are citizens, and there's no question about that. So then equal protection, the idea of making sure that the law is applied equally, that everybody is protected under the law. And again, we'll get to that more when we look at the groups we're talking about in civil rights and the protections of the law to make sure it is equal protection under the law. But then we get to due process. And the idea here was, okay, we've got the Bill of Rights, and it does protect individual citizens from the national government. But due process here also looks at, and this is where we see the expansion, the incorporation, selectively, case by case, amendment by amendment, of the Bill of Rights, so that the individual rights that are enshrined in the Bill of Rights are actually applied to citizens in states. And we see that with the first one, the 1925 case of Gitlow v. New York, a free speech case in which New York is trying to stifle free speech, and the case goes to the Supreme Court, and the Supreme Court says, no, this is a violation of the Constitution. This is our first case in which we are selectively incorporating, but we are looking at this as, you know what, based on the 14th Amendment, the Bill of Rights applies to states, and states have to abide by freedom of speech too. It isn't just an option that you can opt out of anymore. Now, up to that point, Barron v. Baltimore was the law of the land. The Supreme Court ruled about 100 years before that in Barron v. Baltimore. It was an eminent domain case, but the idea was a Bill of Rights didn't apply to states. And for almost 100 years, the precedent of the court said the Bill of Rights didn't apply to states. And so then you see a lot of these states coming up with state laws that infringe slowly, or sometimes not so slowly, on citizens' rights across the board. And so this is where the Supreme Court starts to step in 1925, and you can see the 5 freedoms there in 1931, 37, 40, 47, 58, and 63. So took them 40 years to get there, but ultimately they did, in incorporating each of those freedoms under the First Amendment. And that's selectively incorporating. Notice it's a case-by-case basis, state by state, basically checking them off the list. So New York, you can't violate freedom of speech. Minnesota, you can't violate freedom of the press. Oregon, can't violate freedom of assembly. And the list goes on and on. And that's the idea of selective incorporation. It is selective in that, notice they were done differently. You go down to the Sixth Amendment. Right to counsel in capital cases. We see this under Powell v. Alabama, 1932. It wasn't until Gideon in 1963 we would see felony cases have a right to counsel, as long as it was a felony case, not necessarily a capital crime, accused of murder or something. So that took a while to get there under the Sixth Amendment and incorporating each of those pieces, but ultimately they did, selectively incorporated the Sixth Amendment to apply to states. And you can see all of the states that this was addressed. I mean, Gideon v. Wainwright in Florida, you had Texas, you had North Carolina, Alabama, Louisiana, a number of them applying the Bill of Rights to the states on a case-by-case, amendment-by-amendment basis. And that's the idea of selective incorporation. A really hard concept for students to understand, but really essentially a pretty straightforward one. And it's just applying each of the amendments to the Bill of Rights to the states, so that the states have to abide by them. The states have to give citizens those rights, just like the national government does. Now, Eighth Amendment would be the latest one that was incorporated. This is the excessive bail or excessive fines, and this was in a drug bust. Does the government have the right to take property that is above and beyond what was involved in the drug case? And in this case, in 2019, the Supreme Court said they do not. It is an excessive fine. It goes beyond what they should have done here, and violates the Eighth Amendment. And so they incorporated the Eighth Amendment in 2019. We saw the Second Amendment before that, the right to bear arms, incorporated under D.C. v. Heller initially, and then reiterated in McDonald v. Chicago. And that really is the case that we see today, the one you do need to know, that basically Chicago tries to pass a law that basically restricts gun use in the city of Chicago, and the Supreme Court said nope, it wasn't any good in D.C. v. Heller. D.C. couldn't do it, and you can't either. And so whether it's Chicago or the state of Illinois, nobody can do it. You can't violate the Second Amendment, and that incorporated the Second Amendment to apply to the states. So that's what we see here in selective incorporation. Now let's go to number 3, the Establishment Clause versus free exercise. They are very different. Notice there is no freedom of religion clause. Okay, that's the one we always get from students saying, "Oh, there's freedom of religion." Where do you see that? Please show me, because it doesn't say that. It says, "Make no law respecting an establishment of religion or prohibiting free exercise thereof." Okay, these are 2 separate clauses. So if you ever have to identify one, don't say freedom of religion. Say establishment of religion, or say free exercise. Those are the 2 clauses we're looking at here: Establishment Clause and free exercise. Establishment, the idea of the government showing a preference for one religion over another. We are not a theocracy. We do not have a religious-based government. And so that would violate our Establishment Clause. And so the more loose interpretation justices tend to look at this as a wall of separation, a strict separation, if you will. Conservative justices not so much, looking at it more in terms of government stepping in to help religions in general, not necessarily establishing a religion. So there is some parsing there, but the idea of the establishment is the government not showing a particular preference for one religion over another, etc. And the case of Engel v. Vitale is the case we saw with the Establishment Clause. Just because you want to have a non-denominational prayer that doesn't favor one religion over another, and allow people to voluntarily recite it in school, it's still a violation of the Establishment Clause. It's showing a preference for one religion over another and violates that wall of separation that we saw there. So that's essentially the Establishment Clause in terms of what we see there. Free exercise is the idea of inhibiting people from being able to participate or actively participate in their religion, okay? As long as it doesn't violate the law, okay? And we can get into cases where that was found by the court to be unconstitutional in terms of somebody trying to say, hey, I should be able to marry multiple people. I should be able to participate in drug use that is normally illegal. You can't violate those things and think that it's going to be okay just because you're claiming it's a religious free exercise. That doesn't. The idea there is that the courts have not agreed with cases that have come down in that capacity. However, if it is within the letter of the law and it is a violation of the ability of someone to be able to actively exercise their religious rights, then the court has come down on the side of those individuals, and we definitely see that in terms of the free exercise clause in that capacity. Remember, government can't compel people to accept a certain belief system. That essentially is what we talked about there with the Establishment Clause. But they also can't prohibit them or keep them from being able to practice their religion, and that is the violation that we see under free exercise. Now let's look at some what we call symbolic speech, which is important here, because what we saw is a case involving Tinker v. Des Moines. Mary Beth Tinker actually came to WJ a couple of years ago. We had her speak. I worked with the Youth and Government Club to bring her in to talk to students about symbolic speech and the importance of making your voice heard. And really fascinating to hear. She goes all across the country still talking about this experience. But she wasn't an activist. She was someone who was opposing, her family was opposing the Vietnam War. And so she wore the armband to school, didn't even say anything about it, never gave up and got a speech, never did anything like that. She was actually, she talks about the experience as being very timid. She was very fearful she was going to be suspended and that people were going to look at her differently and that kind of thing, and she was really worried about that. But it was just wearing an armband to school. She didn't, like I said, she didn't give any type of a speech or disrupt the class in any way. But yet they suspended her and her brother. They fought it. It went to the Supreme Court, and the Supreme Court said symbolic speech is free speech as long as it isn't a disruption to education, to the learning environment. I will say if it doesn't disrupt the educational experience, then you're fine. We talked the other day about can I eat in class? Well, yeah, if you, as long as it doesn't disrupt the educational experience for you or for others around you, that's an important piece, right? You can't disrupt the learning environment for others, even though it may not be disrupting you. And in this case, it wasn't. And the Supreme Court found that just by wearing the armband, would be just like, wearing a piece of clothing, a brightly colored piece of clothing to school one day. That's not a disruption to the learning environment. And they found that the suspension was unconstitutional. So a significant case in terms of symbolic speech. Now, we've seen other school cases include Hazelwood v. Kuhlmeyer. This is the idea of censorship. Can administrators censor a school newspaper? The Supreme Court said they can. Now, in Montgomery County, we do not have what is called prior review. That's censorship before it gets published. We don't have that, but many school systems do. I remember going to a teacher workshop down in Austin, Texas, with teachers that taught in Texas, and they do have prior review. They have to submit all of their newspaper pages and stories, all of their yearbooks, and all of their news items before they go up on the internet. They had to submit them to administrators for prior approval. What we call prior review. We do not have that in Montgomery County. That is not enshrined as something we do not have. But under Hazelwood v. Kuhlmeyer, the school system does have the ability to be able to do that if they want to. Okay. And under Lee v. Weissman, can a member of the clergy, can a pastor or a priest get up and give a prayer? Well, violation of the Establishment Clause there. Under the case, the Supreme Court said in 1992 that you cannot get up and just have a member of the clergy do that without it showing some type of preference for one religion or another. It violates the Establishment Clause. And then in Westside Community v. Mergens, this is the idea that, well, if other clubs and groups can form, can religious clubs and groups form if it's students that are leading it? And the Supreme Court said yes, they can. They do have that right. In terms of free exercise, that's a really good one as well, in terms of an example there. The Westside Community v. Mergens case, definitely in terms of free exercise, in terms of forming a religious group, as long as it's organized by students, not by teachers or administrators or someone outside. It's got to be organized by the individual students themselves. So the court has definitely struck down school prayer. We mentioned school prayer earlier in terms of the Engel v. Vitale case. Just because it's optional, but it's done during the school day and it's led by administrators or teachers or other faculty, that is a violation of the Establishment Clause. Creationism, again, violation of Establishment Clause. Ministers at graduation, violation of Establishment Clause. Organized prayer at football games, again, you want to do that on the side with your players or whatever, fine, but you can't do that over the loudspeaker. You can't do that having a member of the clergy come in and give a prayer before the game. Now, this also doesn't preclude students from doing it any type of free exercise of their religion on their own time, in between classes, maybe right before a test. They say a prayer to help me on this test. I really need it. Before school, at lunch, after school, at home. Those are all options that students still do have, but they are limited in terms of the school day because of that disruption aspect and that establishment aspect. We saw a case in West Virginia v. Barnett. In terms of the Pledge of Allegiance, do we have to say the Pledge of Allegiance? You don't. Jehovah's Witnesses fought this case in 1943, and you don't have to You don't have to say a Pledge of Allegiance in those terms. Also, the idea here was it wasn't just religious reasons, but for any reason, and they really had to specify that. The importance there was you couldn't compel someone to say a pledge under those terms if it violated their religion. And the concern there was during wartime, do we pledge allegiance to a nation that is at war? And that was a concern. So we saw that shot down because of the idea there of not being able to have a requirement of exercise as well. So compelling exercise of speech is just as bad as the violating the free exercise of that speech. Let's talk about the Fifth Amendment in number 5 here, appropriate, right? 5, Fifth Amendment. The idea of eminent domain. Now, there's a bunch of stuff in Fifth Amendment, things that we always don't even think about. And eminent domain is definitely one that we usually don't have top of mind. Usually when we hear the Fifth Amendment, we hear you have the right to remain silent, right? The Miranda rights come out of the Fifth Amendment, as well as double jeopardy, the idea that you can't be charged with the same crime twice. If you're found innocent and acquitted, if you're acquitted, you can't be tried again for the same crime. So that's usually where we hear Fifth Amendment. But there's also an eminent domain aspect in that the government can come in and seize private property if they give you fair market value for the property and they're using it for some semblance of public use. Now, there was a case, Kello v. New London, Connecticut, in which they did try and take it for what was called a public-private partnership. That was in development. It was very controversial. It led to the Supreme Court case in which the Supreme Court actually stepped in and said the city did have the right to take the property, even though it was going to be a public-private partnership development kind of thing, and that was involved. And that set off a flurry of state constitutional amendments across the country that were basically enshrining in their constitution the right of freedom of property, so that the government couldn't take your property. This idea of regulatory taking and the concern there. People were worried about losing their fair market value as a result of this, and then it was going to drop in price and would be less beneficial in terms of that significance. So that was the concern. But eminent domain still exists. The ICC, the Inter-County Connector, is a great example of eminent domain. They took many properties in terms of building that Highway 200 across the county, and that is a great example of eminent domain. A lot of times when schools, and GW, I think, did this, when schools in the county are expanding, in a lot of cases, they'll take properties near the school or adjacent to the school, and that's also through eminent domain that the state would do that and take the property for public use. They're going to expand the school system, and so they're taking private property in order to do that. All of that is covered under eminent domain, and they do have the right to do that under eminent domain as long as they're giving you fair market value for that property, and that is the key. Now, let's talk about freedom of speech for a second. We've seen some freedoms in terms of exceptions to the blanket language of freedom of speech. We know that the belief is protected. We know that the action, however, sometimes can be limited. And we saw, and we're seeing a lot of this play out right now with President Trump's impeachment trial, and the concerns about how much did he have freedom of speech versus how much did his speech potentially or allegedly incite others to partake in that action at the Capitol on January 6th. So how far does your speech go? I had a professor one time that said, your freedom of speech ends where someone else's begins. And I always like that, because if it starts to infringe on someone else's freedom of speech in terms of the rights and the liberties that they have, then all of a sudden that's not freedom of speech anymore. You're infringing on someone else's rights, and that's a violation of their rights, which means you don't have it anymore. So speech many times is kind of that in between in terms of beliefs and actions. And we see some examples where this is where this is the case when it comes to libel, obscenity, and fighting words. So let's drill down in that for a second. Libel is the idea of you're writing it down on paper, you're publishing it, and you're defaming another person. You're saying something about them that is false. One, you have to prove that it's false. Two, there has to be actual malice in proving it. And in this case, it was a newspaper ad that was allegedly libeling Sullivan, and he didn't like it. So he filed suit against the New York Times and many of the people who issued the ad. And the concern there during the civil rights movement, and the concern there was the newspaper must have known that what they had in there were statements that were false, and so they must have known, and therefore they were guilty as charged. Well, Sullivan was an elected official, and the one thing we know about libel is it's really hard to prove libel against a public official, against an elected official, because when you're in the public domain, almost anything goes. I mean, you're a target in a lot of cases, and so you give up the rights of a private citizen when you run for office, and so really hard to prove in those particular aspects. There have been people who have sued and been successful in it, but more often than not, it is a really high standard that the Supreme Court, and they did side with the New York Times on this one, because of the fact that they said even if that was the case. Sullivan was an elected official. The New York Times didn't know about this, and even if they had, the issue wasn't true malice in terms of it would have harmed him egregiously in terms of doing, and so they sided with the New York Times on that, and that has pretty much been the precedent on libel ever since. So for the last 60 years, a little less, that has been the libel standard that we have seen. Now, obscenity, we know it when we see it. That's essentially the background we get on Miller v. California. It applies what we call the slaps test. This idea of does the work that we're looking at, is it obscene? Well, the community is going to determine whether it is or not, whether it is just obscene or whether it is a work of art. And so the standard that they use is called the slaps test. Does it lack serious literary or artistic or political or scientific value? And this is the idea of I know it when I see it. And every community is different. Just because it isn't obscene in New York City doesn't mean it's not obscene in Peoria. And that's the idea behind this. So the court basically developed this Miller test, if you will, for obscenity, in that we're looking at this from a standard, a community standard that is based on contemporary standards, but within that community. And so that can mean different things to different people. We also know that fighting words, the idea here is that hate speech laws have been overturned. The Supreme Court has upheld them. However, hate crime laws have been upheld as well. So we've seen hate speech overturned in terms of it is a freedom of speech as long as it doesn't incite action, incite violence. That is where you cross a line, right? The idea of free speech or a belief versus speech that incites an action or violence, that would not be free speech at all. And then we have the idea of commercial speech, which is a little different. The idea here is there can be laws that lead to advertising in terms of something that you're advertising that is false and can be proven to be false, or misleading in terms of getting customers to buy it. There are laws that can punish that, and we've seen that upheld in courts as well in those terms. Now, one case that was another school case that had to do with here, students, the Morse v. Frederick is the one students always like to talk about. It's the Bong Hits for Jesus case. And this was essentially students that were basically trying to endorse the idea of illegal drug activity and being able to use illegal drugs. And they said, hey, it's our free speech rights. And the Supreme Court came back and said, no, it isn't, and you don't have the right to do it. Just because you say free speech. You can't claim free speech. You can't yell fire in a crowded theater. That is illegal, okay? You can be arrested or fined for that. And in the same fashion, just because it's free speech, you can't get up in front of a stadium full of people and tell them something, or use, we've also seen in cases where they've used foul language, and that's not free speech either. So again, there are instances in which your freedoms end where someone else's begin, and that's important to note here as well. Okay, let's shift gears now and talk about, go back to this idea of due process, because we did talk a little bit about it before. But the idea of due process here is basically broken down into two aspects. And we get due process from two places. And I always get this question from students. What is the difference between the Fifth Amendment and the 14th 14th Amendment, and we're going to cover that here. But let's talk about procedural and substantive first, and then we'll get into the nuances of the 5th and 14th Amendment. Procedural due process is, are you following the checklist? Is there a particular checklist of what you should be doing here, and are you addressing it as such? Are you following the rights that have been laid out for you in terms of did you give the accused the right to remain silent? Did you give them the right to a lawyer? Did you give them the right to a trial by jury? Do you give them a right to a trial by a jury of their peers? Did you give them a right to a speedy trial by jury? All of these things are part of the methodology of a case, and following the procedures, writ of habeas corpus. I need to know that I need to go before a judge and know what I'm being accused of. I need to be told. I need to be told that you're a cop, and I need to be told that that I am being arrested for, whatever. All of those are procedures that need to be followed. Now, the cop one, there are times where they don't necessarily have to tell you that they're a cop unless they're, again, writ of habeas corpus. They're telling you what you're being charged with, okay? So we see that. But the point here is it's procedural. You're following the process in terms of what is being outlined in the Bill of Rights. And we see this enshrined in different aspects of the 4th through the 8th Amendments. The 4th starting with search and seizure, the 8th with excessive bail or fines. That's kind of the idea. Are you following the checklist, if you will? Substantive due process is the idea of fairness. Is the way the law is being applied to this individual through the process of their trial, through the process of their arrest and their indictment and their access to a lawyer and witnesses and this, is it fair in terms of it's being applied to everyone across the board? And that was a concern. The idea here in Re-Gault, it was a case from 1967. Again, another one we don't really talk about much anymore. But there was a different standard applied to minors, juveniles, than was applied to adults. And under this case, they said they violated the substantive due process of the law. You weren't giving the juveniles the same access to the resources and the due process of the law as you were giving to adults, and that was not fair to. It was not fair under the due process clause. It was not fair to the juveniles that were being accused, and so that is a problem and a violation of the Constitution. So that is significant here. Now, the 5th Amendment outlines, and we talked about a couple of them: the right to remain silent, the right to be free from double jeopardy, the right to a lawyer, all of those kind of stemming from the 5th Amendment. But essentially, the idea of due process there is, are you following those procedures that are outlined in the 5th Amendment? 14th Amendment looked at this and said due process, again, think Reconstruction amendments. 14th Amendment looked at this and said, is due process being applied across the entire Bill of Rights? And this opened up selective incorporation. This 14th Amendment opened up the opportunity to look at the Bill of Rights and say, are we selectively incorporating the First Amendment and the Second Amendment and the Fourth Amendment and the Fifth and Sixth and Seventh and Eighth? Are we incorporating them and applying them to the states? And now we have case by case the ability to do that. That's selective incorporation. And it's under the 14th Amendment that we're able to incorporate all of those amendments, case by case, amendment by amendment. So that's the significance here of due process and the role that it played, because it really is critical. Without the 14th Amendment, you don't have due process, you don't have selective incorporation, you don't have individual freedoms from state laws under the Bill of Rights. And that was the critical game changer that really made a difference here. All right, as we begin to close this out, let's look at the Fourth Amendment for a second. The idea of search and seizure. Can people just come into your home and start looking around? Well, of course not. They need a warrant. Well, in Map v. Ohio, if they come in looking for something and they find something else, can they still charge you? And the answer is no, they can't. The warrant has to be written in a way that is either really broad, and judges don't like to do that. They like to write them very narrow for this exact reason. Because in so doing, in Map v. Ohio, Dolry Map being being investigated, and the police got a warrant to come check out their house, worried about some wacky weed that they may have had there. And they found obscene pictures as a result of this. And they had no warrant for the obscene pictures, the obscenity, but they arrested him anyway, and in searching the home, and that was what they charged him with. And he said, well, that wasn't what was on the warrant. The lawyer said that was a violation of his Fourth Amendment rights. They took it to the Supreme Court, and the Supreme Court agreed. They said it's a violation of his search and seizure rights under the Fourth Amendment. They didn't come in looking for that. They shouldn't have charged him with that. The warrant had to have said that it was for that. And so that's why police officers today try and get a warrant that is much broader in terms of anything we find that it may be or potentially illegal. We have the opportunity to have reasonable suspicion to search further. Judges will try and narrow that down, but that is essentially the back and forth that we see today. So a reasonable expectation of privacy. We don't have phone booths anymore, but do you have that reasonable expectation of privacy? You do. If you're closing the door on the phone booth, that is a reasonable expectation of privacy. Now, your school locker, not so much. Not so much. Any trash you throw out, also not so much. You're giving it away. You're putting it at the curb. You're basically throwing it out there to the public. Now, people don't choose to open it up and start going through it, mind you. But the idea is your trash is no longer yours. You're giving it to a landfill. If they find it in a landfill and implicate you in something, then that is reasonable, and that has been found to be the case. A house is a person's castle. There is a reasonable expectation of privacy there, and that is about the only one that is like in lockstep, like absolutely got to have a warrant today, is really your home. Even with your car, if you're standing there with the door open, it's an invitation. Cops can say, hey, they were gesturing that it was open. It was an open door policy. I could go right in. So the idea there, if you get out of the car, make sure you shut the door behind you and make sure the door closes, along those lines. But that has been a case that's come before the court. And they have said, well, in that case, if the person says yes to a search, they give the cops the ability to search the entire car at that point. If you're being arrested, obviously no expectation of privacy, none whatsoever. Anything in plain view, also not an expectation of privacy, and that goes back to the car, right? They can't search the trunk because they can't see it, but if they see something in the back seat, that kind of thing, that would definitely have an aspect. And that's important to note in terms of search and seizure. But Mapp v. Ohio is the case that basically established this idea of search and seizure and the importance of a warrant in terms of carrying out any police searches that are going on in the home or in a locker, that kind of thing. One of the cases we'll look at with the high school assessment is TLO v. New Jersey v. TLO. And this was a case where they wanted to search the purse for illegal drugs. And they said, no, you can't do that. And they said, you're on school grounds. It may be your purse, but you've walked onto school grounds with it, and we can search anything on your person, including a book bag, duffel bag, purse, any type of other boxes or bags or anything that comes onto school grounds can be searched at that point. All right, we move on to number 9, the idea of good faith exception. This is the idea that if someone is acting in good faith and there's a technical error, they will allow a good faith exception. They're much tighter on this than they used to be, the courts, but they are looking at this. If there was a warrant that wasn't exactly the way it was supposed to be. Now again, go back to Mapp v. Ohio, and you can see it was a warrant that wasn't even for that, and the court threw it out. So this kind of goes back and forth, and it really is dependent on the situation. But there is something out there called a good faith exception that does try and address this in terms of technical errors made by police and whatnot. But it is a really high standard. You really can't try and get away with a whole lot here and get away with it. Another interesting one that we don't talk about much anymore, but is involved in search and seizure, is Kelo. Kelo was cops using a thermal imaging device going through a neighborhood and trying to see if there were unusual amounts of radiation or heat coming from homes to indicate that they were growing something downstairs that they shouldn't be. And so then going and basically having reasonable suspicion that something is there, and so they didn't have a warrant, and they went in and busted the marijuana plant growing operation in the basement. Supreme Court threw that out, said you can't do that. That is a violation of a person's home. And remember the list. The home is about the only thing that is sacred anymore. You have to have a warrant to go into somebody's home in terms of addressing that. The drug testing, we saw this with Board of Ed v. Earls. Can they require drug testing? They can. And that goes all the way down to high school students with extracurriculars. You may have rights outside of school, but in school, the idea there is if they have a suspicion or otherwise, can they test the whole team? They can. They can absolutely do that under the Fourth Amendment, and the Supreme Court has upheld that, including sobriety checks at different checkpoints that police may set up, those types of things. And again, they're looking at public safety here in terms of doing it, so that really is the critical point. So I mentioned the New Jersey v. TLO case. This is the locker, the purse. Just because it's your locker doesn't mean it's your locker. It is given to you by the school, by the government, and they can search it at any time. Teachers can't search it. It's usually administrators and a witness, another administrator or security or whatnot. Usually need more than one person there to be a witness to it, but they have the right to do so. And you have very little grounds on school property in terms of being free from search and seizure. And as I said, not teachers, but everybody else, security, admins, and other administrators or those in MCPS have the ability to be able to do that. The Miranda v. Arizona, we kind of already talked about with the Fifth Amendment, the right to remain silent. Here's the Miranda card that police do carry around. You have the right to remain silent. Anything you say can and will be used against you in a court of law. You have the right to an attorney if you cannot afford one. One will be appointed to you at the cost of the court. Do you understand these rights? At any time after that question is issued, whatever you say can be used against you at that point. Even if it's, I want a lawyer. I want a lawyer. That can be used against you in some way, shape, or form. Hey, they were saying they wanted a lawyer very vehemently. What does that say about their guilt or innocence? So we've seen all kinds of things in that respect. In Miranda v. Arizona, he wasn't informed of his rights to an attorney or his rights to remain silent, and that was a significant impact on the case to get it overturned. It was unconstitutional, violating his Fifth Amendment rights there. In Gideon, this is the Sixth Amendment. If you have the right to a lawyer in a capital case, in a murder trial, but it's not murder, but it is a felony, do you still have the same rights? Gideon was not afforded those rights. Gideon was told by the judge, this isn't a murder trial, and because it isn't a capital crime, a murder case, you don't have the right to a lawyer. He didn't agree. He petitioned in forma pauperis, being poor, not being able to pay the filing fee. He petitioned to the Supreme Court, and they remanded his case. They did say they didn't let him off. They actually remanded the case. They sent it back to the lower court, but they did say that he was supposed to have the right to counsel under the Sixth Amendment. Again, the idea here incorporating the right to counsel for non-capital offenses. For felonies. So he was being accused of breaking and entering and robbing a vending machine in a bar. He wasn't there, but when he was picked up, he had a pocket full of nickels, and he was playing poker with some buddies across town. That he didn't know all of them, and so there was a lot of issues with corroborating the story. He wasn't given a lawyer to be able to research and conduct some investigation of his own. So the Supreme Court said, you had the right to a lawyer. Let's remand the case to the district court, send it back there. They gave him a lawyer, and they did find him to be innocent. There's a really good Netflix video called Gideon's Trumpet that is all about this case. It stars Henry Fonda. It's one of those old movies, so if you're an old movie buff like me, you'll love the movie. And Henry Fonda plays Gideon. Clarence Earl Gideon in the case. Really great movie. It's really well done in terms of showing the case of the right to counsel. But that incorporated the Sixth Amendment and the right to counsel in that particular regard. We saw the Eighth Amendment in terms of the death penalty not being cruel and unusual punishment. Now, we also see in Timms v. Indiana, the case I mentioned earlier, incorporating the Eighth Amendment such that excessive fines or excessive bail in that case was unconstitutional and incorporated the amendment against Indiana that the Bill of Rights of the Eighth Amendment had to apply to the states. In Gregg v. Georgia, we saw the death penalty was allowed, was constitutional. It was not cruel and unusual punishment under the Constitution, and that essentially has been upheld ever since. Now, we've seen some fine lines as it relates to lethal injection and use of drugs that can have other side effects and aspects, and that remains to be seen how that's going to play out. To be continued in the years ahead with the court. We'll see how that plays, but that essentially is the role of civil liberties in our society today. And that thus ends the top 12 highlights on civil liberties. I hope you found this helpful. I will see you once again in the next chapter when we talk all about civil rights.